Lawyers are not supposed to file groundless lawsuits. When they do, the worst that usually happens is the case gets dismissed and the losing side has to pay court costs. Now, in rare instances, though, when a civil action is frivolous enough or filed in sufficiently bad faith or under false premises, the court can sanction the attorneys involved. Well, today, Sidney Powell, Lynn Wood, and other lawyers who sued to get election results thrown out in Michigan faced a federal judge. By most accounts, it did not go well for them.
A federal judge has just granted the motion to dismiss the criminal case against Donald Trump for his efforts to overturn the 2020 election. This follows the release of a massive final report from special counsel Jack Smith, detailing the evidence his office gathered over 2 years of investigation. We are looking at the final word on a government of laws and not of men. Let's play this clip.
Diligence. How do you think today's hearing went?
Well, it was 6 hours, so it certainly was. It was a very educational experience, I think, for a lot of folks who watched it. It shows that there is a lot of due diligence happening with regards to this question before the court. Should there be consequences for when attorneys who use their privilege and access to the court to try to undermine democracy with no facts, frivolous claims, with one goal of sowing seeds of doubt among the public about the integrity of our.
Good evening. We begin tonight with a definitive turning point in American legal and political history. On January 7th, 2025, Special Counsel Jack Smith delivered a 2-volume final report to the Attorney General of the United States. This report marks the formal conclusion of 2 of the most significant criminal investigations in the history of the Department of Justice. The first investigation focused on efforts to interfere with the lawful transfer of power after the 2020 presidential election. The second focused on the possession of highly classified documents at the Mar-a-Lago Social Club. The delivery of this report follows a monumental shift in the legal landscape. On November 25, 2024, the special counsel moved to dismiss the federal election case against Donald Trump. This decision was not based on a lack of evidence or a change in the merits of the prosecution. Instead, it was based on the Department of Justice's long-standing policy that the Constitution forbids the federal indictment and prosecution of a sitting president. Because Donald Trump was re-elected as President of the United States, the department determined the case must be dismissed without prejudice before his inauguration on January 20, 2025. The special counsel's report provides a detailed factual record for the public and for history. Jack Smith stated that his office was guided by one North Star, to follow the facts and the law wherever they led. He emphasized that the department's mandate is that power, politics, status, wealth, and favor should not impede justice under the law. While the cases were not able to be brought to trial, Smith stated that the fact his team stood up for the rule of law still matters. He noted that the example set for others to fight for justice without regard for personal cost is a vital contribution to the country. The investigation into the 2020 election revealed what the report describes as an unprecedented criminal effort to overturn legitimate results. The report alleges that when lawful means of challenging the election failed, the former president resorted to a series of criminal efforts to retain power. These efforts included inducing state officials to ignore true vote counts. They included manufacturing fraudulent slates of presidential electors in 7 states. They also included attempts to force Justice Department officials and the vice president to act in contravention of their oaths. The through line of these efforts was the use of knowingly false claims of election fraud. The evidence shows that these lies were used as a weapon to defeat a foundational federal government function. The special counsel's office investigated whether the former president actually believed the claims he was making. The report concludes that evidence from a variety of sources established he knew there was no outcome determinative fraud. High-ranking officials in his own administration told him directly that there was no evidence to support his claims. His private advisors, both inside and outside of his campaign, told him the same thing. On November 13, 2020, his own campaign even conceded its litigation in Arizona, a state that was pivotal to the election outcome. State officials and legislators whom he pressured to change vote counts rebuffed him and told him his fraud claims were wrong. These officials frequently informed him of the facts through both private statements and public press releases. The report notes that the former president and his co-conspirators could not have believed their specific fraud claims because the numbers they cited vacillated wildly or were objectively impossible. For example, Claims about voting machines were privately acknowledged as sounding crazy before they were publicly amplified. The former president also made comments that implicitly acknowledged he knew he had lost the election. In a January 3, 2021 Oval Office meeting, he stated that it was too late for us and that they would give that to the next guy, referring to President-elect Biden. Despite this private acknowledgement, the report details how he directed his deceit at the constitutional process of certifying votes. This process is governed by the Electoral Count Act of 1887. For more than 130 years, this process had operated in a peaceful and orderly manner until it was obstructed in 2021. The first pillar of the alleged scheme involved targeting the electoral process at the state level. The report states that the former president contacted state legislators and executives to pressure them with false claims of fraud. He made these claims only to state officials who shared his political affiliation and supported him, and only in states that he had lost. For example, on November 22, 2020, he and a private attorney called the Speaker of the Arizona House of Representatives. They used false fraud claims to try to convince the Speaker to replace Arizona's legitimate electors. When the Speaker requested evidence to support these claims, the private attorney conceded a week later that they did not have evidence, only lots of theories. Similar pressure was applied in Georgia. On January 2, 2021, the former president called Georgia's Secretary of State and urged him to find 11,680 votes. This was the exact margin of victory for Joe Biden in that state. When the Secretary of State refuted the false claims, the former president issued a threat, stating that not reporting the alleged fraud was a criminal offense and a big risk. In Michigan, state legislators were invited to the White House on November 20th. There, they were presented with false claims of fraud. The Michigan Senate Majority Leader told the former president that he had lost the election because he had underperformed with educated females. The report highlights that trusted state and party officials told the former president from the outset that there was no evidence of fraud. In Arizona, the governor used a baseball metaphor to tell him it was the ninth inning, and he was several runs down. In Pennsylvania, the chairman of the state's Republican Party explained that the shift in the vote count was expected due to 1.75 million mail-in ballots. Despite these conversations, the former president never contacted other election officials to determine if specific allegations had merit. The second pillar of the effort was the fraudulent elector plan. This plan involved organizing people who would have served as electors if the former president had won the popular vote in 7 contested states. These people were asked to sign and send false certifications to Washington claiming to be the legitimate electors. This plan quickly transformed from a legal contingency into a corrupt strategy to obstruct the certification proceeding. The report notes that most of the fraudulent electors were deceived. They were falsely told their votes would be used only if ongoing litigation was successful. Some individuals recognized the plan was improper. One elector nominee in Pennsylvania declined to participate, recognizing it as an attempt to overthrow the government. However, the plan moved forward, and fraudulent certifications were sent to Washington, D.C. By December 19th, the former president began directing his supporters to gather in Washington for a big protest on January 6th, promising it will be wild. The third pillar of the scheme involved the misuse of federal power through the Department of Justice. The former president was frustrated that the department's criminal investigations had identified no evidence of substantial fraud. On December 1, 2020, the Attorney General publicly stated that the department had not seen fraud on a scale that could have changed the election outcome. In response, the former president considered appointing a civil attorney within the department, referred to as co-conspirator 4, as the acting Attorney General. This individual was willing to use the department to spread false claims and pressure state legislatures. During one discussion, the former president told department leadership to just say that the election was corrupt and leave the rest to me and the Republican congressman. On December 28th, co-conspirator 4 proposed a letter to state officials falsely claiming the department had identified significant concerns about the election outcome. The acting deputy attorney general rejected this, stating he knew of nothing that would support such a statement. He also noted the department had no role in how states administer their own elections. On January 3, 2021, the former president offered the position of acting attorney general to co-conspirator 4. This led to a meeting in the Oval Office where senior officials from the Justice Department and the White House counsel's office were present. The former president was informed that if he made the appointment, there would be mass resignations within the department and the White House. He was told the new acting attorney general would be leading a graveyard. Only after this warning did the former president decide not to move forward with the appointment. The final phase of the effort focused on the vice president. The plan was for Vice President Mike Pence to use his ministerial role as president of the Senate to decline to count legitimate electoral certificates. This strategy was spearheaded by a private attorney who had recently conceded the plan was not supported by the Constitution or federal law. In repeated conversations, the former president pressed the vice president to change the election outcome. When the vice president refused, the former president told him that hundreds of thousands of people would hate his guts and that he was too honest. On January 4th, a meeting was held in the Oval Office where a private attorney outlined two ways the vice president could affect the outcome. He could either reject the legitimate electors outright or send them back to state legislatures. The attorney admitted both proposals violated the Electoral Count Act and were untested. The vice president again stated he did not believe he had the authority to do what was being asked. That night, during a speech in Georgia, the former president told a crowd he hoped the vice president would come through for us, adding that if he didn't, he wouldn't like him as much. The events culminated on January 6, 2021. That morning, the former president tweeted that if the vice president comes through for us, we will win the presidency. Just before giving his speech at the Ellipse, he phoned the vice president one last time. When the vice president confirmed he would not act as requested, the former president expressed anger and inserted language targeting him into the planned speech. During the Ellipse speech, the former president repeated lies about dead voters and fraudulent vote dumps. He told his supporters that the election had been stolen and that the discovery of fraud licensed them to go by very different rules. He used the word fight more than 10 times. He told the crowd that if you don't fight like hell, you're not going to have a country anymore. He then directed his supporters to march to the Capitol. At 1 p.m., the vice president began the certification proceeding. Outside, the crowd of supporters broke through barriers and violently attacked law enforcement officers. Officers were assaulted with bear spray, metal bats, and flagpoles. At 2:13 p.m., the building was breached, forcing the Senate to recess. While in the White House dining room, the former president watched news coverage of the riot. His advisors urged him to issue a calming message, but he resisted, remarking that the people were angry because the election was stolen. At 2:24 p.m., knowing the riot was ongoing, he issued a tweet attacking the vice president for not having the courage to do what should have been done. 1 minute later, the Secret Service was forced to evacuate the vice president to a secure location. When an advisor informed the former president of this evacuation, he replied, "So what?" Throughout the afternoon, rioters hunted for the vice president and other lawmakers, chanting, "Hang Mike Pence." The special counsel's report argues that the violence was foreseeable. The former president had remarked the night before that his supporters were angry. During his speech, he had told them to show strength and be strong. He did not ask his supporters to leave the Capitol until 4:17 p.m. in a video where he also told them, "We love you and you're very special." At 6:01 p.m., he tweeted that these events happen when a landslide victory is viciously stripped away. He told them to remember this day forever. The report notes that the former president has continued to support those who attacked the Capitol, calling them patriots and hostages. He has championed the January 6th Choir, a group of defendants detained for their dangerousness. Based on these facts, the special counsel's office originally sought an indictment on 4 federal charges. These included conspiracy to defraud the United States and obstruction of an official proceeding. However, the Supreme Court's July 2024 ruling in Trump v. United States introduced the concept of presidential immunity. The court held that presidents have absolute immunity for core official conduct. They have at least presumptive immunity for other official acts. They have no immunity for unofficial conduct. This ruling forced the special counsel to obtain a superseding indictment focused only on conduct that was not immune. The special counsel concluded that the fraudulent elector plan and the pressure on state officials were unofficial acts as a candidate, not as president. Despite these legal theories, the re-election of Donald Trump triggered a categorical bar on prosecution. The Department of Justice concluded that the Constitution prohibits the continued indictment and prosecution of a sitting president. This led to the formal dismissal of the cases on November 25, 2024. The special counsel stood by the strength of the government's proof, stating that but for the election, the evidence was sufficient to obtain and sustain a conviction at trial. The consequences for the former president's legal team have also been severe. A group of lawyers who directed Stop the Steal cases have faced major disciplinary actions. Rudy Giuliani, described as a field marshal for the effort, was disbarred in both New York and the District of Columbia. Disciplinary boards cited his utter disregard for facts in challenging the 2020 election results. He was also found liable for $148 million in a defamation case brought by Georgia election workers, leading him to declare bankruptcy. John Eastman, an architect of the campaign, faced 10 disciplinary charges in California. A judge found him culpable of seeking to mislead a court and engaging in moral turpitude. The judge recommended that he be stripped of his license to practice law. Jenna Ellis, another key figure, pleaded guilty to a felony charge in Georgia for aiding and abetting false statements. She was also suspended from practicing law for 3 years in Colorado. In her settlement, she acknowledged the harm caused to the nation by the post-election activities. Jeffrey Clark, the Justice Department official who supported the effort, also faces potential disbarment. A disciplinary panel found he violated ethics rules for engaging in dishonest conduct. The report emphasizes that these penalties reflect the gravity of the misconduct and serve as a warning to future lawyers against abusing the legal system for political gain. The judiciary's response to these lawyers has evolved over time. In August 2021, a federal judge in Michigan sanctioned 9 pro-Trump lawyers, including Sidney Powell and Lynn Wood. The judge called their lawsuit a historic and profound abuse of the judicial process. They were ordered to pay hundreds of thousands of dollars in legal fees and undergo mandatory ethics training. The judge stated that the lawsuit was aimed at sowing seeds of doubt about the integrity of the election. By 2025, the relationship between the federal judiciary and the executive branch reached what some observers call a breaking point. Judges began moving toward contempt proceedings and criminal referrals for government lawyers who defied court orders. In immigration cases, individual Department of Justice and Department of Homeland Security lawyers were forced to testify under oath about whether they misled the court. Judges found probable cause that some officials broke the law by ignoring court orders. A major development in the investigation was the piercing of attorney-client privilege. In March 2023, a federal judge ordered attorney Evan Corcoran to testify before a grand jury. This was done under the crime-fraud exception, which applies when legal advice may have been part of a crime. The judge believed something illegal might have occurred in the handling of classified documents at Mar-a-Lago. The investigation revealed a pattern where the former president's team slow-walked document production. They signed certification letters saying all material was returned, but the FBI later found many more documents. While the federal cases are now dismissed, the final report from Jack Smith serves as a permanent historical record. The report explains that the decision to prosecute was compelled by the principles of federal prosecution. These principles require prosecutors to consider if a prosecution serves a substantial federal interest. Smith determined that multiple federal interests were at stake. These included the integrity of the electoral process and the peaceful transfer of power. They included the interest in counting every citizen's vote and protecting election officials from violence. The report argues that the former president's conduct went well beyond contesting election results through the legal system. It involved an attempt to obstruct or defeat a key federal government function through fraud and deceit. This was done in contravention of the framers' intent to prevent a sitting president from perpetuating himself in power. Article 2 of the Constitution specifically excludes federal officers from serving as electors to prevent cabal, intrigue, and corruption. Smith also addressed the argument that the former president should have been subject only to impeachment. The report clarifies that the framers recognized impeachment was not a substitute for criminal prosecution. The Constitution's impeachment judgment clause expressly contemplates that a party convicted in an impeachment trial remains liable to indictment and punishment according to the law. Impeachment is a political remedy, whereas prosecution is a legal one. The former president's defense team has strongly objected to the release of this report. In a letter to the Attorney General, they demanded that Smith terminate all efforts toward its preparation. They argued that Smith lacked the authority to issue a report because his appointment was unconstitutional. They also claimed the report violates the presumption of innocence for third parties. The defense stated that releasing the report would disrupt the ongoing transition process and violate the Presidential Transition Act. They characterized the report as a politically motivated attack and a lawless political stunt. In response, Jack Smith informed the Attorney General that the defense failed to identify any specific factual objections to the draft. He noted that his office provided the defense with a special accommodation to review the report in person, which is not required by law. Smith stated that upon completing their review, the former president's counsel did not contest a single factual representation. They objected only to its public release. The dismissal of the federal cases does not mean the investigations were without merit, according to the special counsel. Smith explained that the department's view is categorical. The Constitution prohibits the prosecution of a president while he is in office. This rule applies regardless of the gravity of the crimes charged or the strength of the proof. Across the country, other cases have also seen closures. In New York, the former president was convicted on 34 charges of falsifying business records related to payments made before the 2016 election. However, on January 10, 2025, the judge issued an unconditional discharge of his sentence. In Georgia, the state racketeering case was dropped in November 2025 by a new prosecutor who was unable to find anyone willing to take over the case. The report concludes by highlighting the lasting toll of the events of January 6. At least 140 law enforcement officers were assaulted that day. More than 500 people have been criminally charged for their roles in the attack. Many rioters have cited the former president as the reason they traveled to Washington, D.C. Some defendants have sought leniency by blaming him for their belief that the election was fraudulent and that they must take action. Jack Smith's final words in the report emphasize that no person in the United States is so high that they are above the law. He stated that his office strove to uphold the fundamental value that we exist as a government of laws and not of men. While the re-election of the defendant prevents a trial from occurring, the special counsel's office provided this accounting to ensure the facts are preserved for the public interest. The release of the report and the dismissal of the indictments conclude an unprecedented chapter in American law. The legal system has undergone what some have called a stress test. While professional sanctions have been imposed on many involved, the ultimate question of criminal accountability for a former president was redirected by the voters in the 2024 election. The special counsel's office is now formally winding down its operations. Jack Smith has resigned before the inauguration. The detailed evidence of the pressure on state officials, the fake elector scheme, and the events leading to the January 6th attack now rests in the public record. The Department of Justice stands fully behind the merits of the prosecution while adhering to the constitutional requirements of the transition. This has been a comprehensive look at the special counsel's final report and the conclusion of the federal cases against Donald Trump. The documentation of these events marks the end of the legal proceedings, but the factual record will remain a part of American history. Thank you for joining us for this special report. Please remember to subscribe and click the notification bell to stay updated on the latest political and legal developments. Join our newsletter in the description below to receive real stories and real context every day. We will see you in the next one.